Uh, we have seen in Nagraj, both sides, both council have presented. Now, this an element of tradition and custom is being suggested with the Jallikattu and the,
Yeah,
now, if there is a legislation,
right.
and of course, we are keeping Nagraj's judgment in mind,
Yes,
would the custom and the tradition,
yes.
they have a bearing on our understanding of the situation?
So I think we must, the answer, at least I'll formulate the answer. The issue of culture and tradition and custom and tradition was expressly examined in Nagraj and was expressly negative. Your Lordship recalls that.
That's why I'm saying,
Yes.
I'm putting the caveat of Nagraj first.
Right.
You see, not so much the element of, the spectacular sport, etc.
Right.
But suppose, I'm just posing it to you.
Yes, yes.
Suppose, that was one of the way a man can hope to get married to, like a king's daughter or a wealthy man's daughter by getting hold of the rings on the, trinkets on the horns of the bull. Suppose that was a tradition, one of the way of getting a bride for himself.
Right.
Now, suppose that is a tradition which is continuing for time immemorial.
Right.
In this context, something
Yes.
like that. I'm not talking about this as a sport or a sporting activity, not in
Right.
that sense.
Right. So my answer would be this. So let us keep Nagraj aside for a moment. My respectful submission is,
One question more.
yeah,
I'm very poor in understanding.
I'm sorry.
I'm very poor in understanding.
I share that trait.
Your reaction was good, Mr. Divan.
Yeah.
My request is, your yesterday's submission was that this Jallikattu is, as observed by this court, is brutal and cruel.
Yeah, that's a finding of this.
Finding.
Yeah.
So as we understand, and rightly understood, in the form in which Jallikattu custom is being organized by these people, that is, the form is cruel, not Jallikattu as such is cruel. The form in which
Okay, so
the custom Jallikattu being organized, that according to his, the finding is in reference to the form. Rightly understood? No.
Well, let me just put it this way. I'll just answer the question itself. Or I'll answer both the
I'm
questions.
putting next to you. I want your answer first so that I can put the second question to you.
No, so Jallikattu, as your lordships have seen, is statutorily defined, correct? Both under the 2009 Act and under the amendment now. So I will describe it as an event. It's a certain type. It's an event which involves, at least for our purposes, bulls. I don't think you can have.
Why I'm putting this question to you is for one reason.
Right.
When this court examined this Jallikattu
Yeah.
in 2014,
Correct.
the form was different. After the amendment made, the state government came out with certain rules
Right.
with precautions to be taken care of
Yeah.
under the aegis of the collector.
Right.
All formalities have to be done by collector, and then it's be, and any person who violate
Right.
or breach those provisions,
Right.
there's a penal provision also.
Right.
Now, our question to you is,
Yeah.
you have also shown certain photographs to us yesterday.
I didn't show the photographs.
All right.
I showed the report.
All right,
I
let's
read the
report.
reports.
Let's go back to the report.
Yes. I showed you the text. Photographs we'll see later. I said in your lordship's time you'll have a look.
All right, all
I'm
right.
glad your lordship looked at the photo.
What we want to show to you is, once the mechanism is at place,
Right.
which the authorities are put in
Okay.
under their legal framework,
Okay.
any person who is not following those particular rules
Right.
in the manner it has been prescribed,
Right.
he is violating it.
Yeah.
Penal action is also embedded under the same scheme.
Yeah.
Now, what you have shown to us of 2021 or 20th,
22. I showed you 22.
22,
But we have earlier reports as well.
all right. Even if we take the report on the face value,
Yeah.
without being permitting them to come for counter,
Yeah. Which they haven't countered.
they are not counter. At the best, you can say that they are violating the very scheme that they have put in place for the purpose to follow. They have not followed, according to as per the report indicates.
Yes. Okay.
Now, the question is,
I can certainly say that.
so the question is,
Right.
if somebody is not following the rules or the mechanism in place
Right.
while organizing these kind of a customary functions there,
Right.
is the rule bad or the function, the manner in which are being declared by them, that is bad. But the problem is, I'll tell you one thing.
Right.
At least I admit for myself.
Right.
Rules may be in any form, the ground reality is never matched.
Yeah, that is so.
Very clear. But the only question is, we cannot take a cognizance of the ground reality only because it does not match with the scheme. We have to test the scheme on the floor, not the ground reality. If we start taking the ground reality also in examining the scheme, then it will very lay down a very drastic situation to us.
Okay, I think these are valid concerns.
So these are our concerns. We want you to project upon us.
All right. So I might take a little more than half an hour, but I want to first address these concerns. Let me first address the concerns. So I am doing 2 or 3 things at the moment.
Bhaiya,
Sorry.
इसको नीचे करो. We are not seeing the Tushar is sitting.
Problem is in many courts now, Manoj.
इसको नीचे करो.
While Manoj, we would love to see you, and I don't know whether your lordship would love to see us, Manoj. The fact is, we don't get to see you, Manoj.
इसको नीचे कर दो भाई.
It's not you, TV.
No, we're not doing it. I can't see it.
No, that's impossible.
Sorry.
The lawsuits are not losing anything.
The screen to be downwards so that we can see the lawyer.
No, exactly. And it's happening in many courts, Manoj, the same situation.
It cannot be just like that.
Yeah, it's difficult,
We'll
it's
have to do it
difficult.
in the recess.
Okay. Do it.
Do it more than half an hour.
All right.
You go ahead.
Yes. Now I'm answering the question, and I'm answering the question on the premise that there is no Nagraj judgment at all. Okay, let's keep aside the Nagraj judgment, because those arguments as to whether you can have a legislation, etc., I have already made. So keep that aside. However, I am relying on the reasoning of Nagraj. Please consider that there is no such judgment, but I am certainly entitled to present before this court the foundational reasoning on this issue regarding culture. Now, the first point I wish to make is that there is an expression, behavioral ethology, which is the science of animal behavior, which is the first point I want to project. So, behavioral ethology, number one, please note that. The second point I wish to project is that there is a certain biological integrity of the animal itself. And the biological integrity comprises 2 elements, the mental as well as the physical element. Now, keeping in mind, over tens of thousands of years since bulls have been domesticated, there is a certain behavior to bulls, which is what I commend to the court. Now, I'll explain that. And there is a certain physical set of traits and mental set of traits to the bulls, which are completely independent of whether there are rules on the ground or there are no rules, because these things we can't change. We can't change these things. Now, what are the basic essential elements? And then we will come to culture, because that's the nub of this entire issue. What the science tells us is that the manner in which a bull is structured as an animal, in contrast to a horse, for example, is number one, the manner in which its legs, its hooves, all of that is discussed in detail. It may not have been read to your lordship, but it's all discussed in detail.
Para 43.
Yes, your lordship is correct. The way it is, the body structure is that if you are going to engage these bulls in a highly stressful situation, they are going to likely seek to flee. And by keeping them in a pen or keeping them in an enclosure and getting people, as your lordship says, to try and mount the bull, etc., in whatever manner, amounts to per se cruelty. So now let me just step back a minute. Let me just step back. Well, now I'll keep aside the bull. There's a notification which your lordship should have seen from the judgment in Nagraj, but we're not citing the Nagraj. There was a notion of performance animals. And your lordship may recall that there were, at least I recall as a child, going to a circus where there would be, for example, there would be tigers, for example, and there was a lion tamer of considerable fearlessness and courage, etc. And there were a whole series of animals which would come in the circus ring. Then we developed the law and found that this itself, having regard to the nature of animal, these are not really performance animals. These are not performance animals, and therefore it amounted to cruelty per se. So, I mean, the ringmaster may be cracking a whip and not actually, the whip may not be actually touching the beast. So, it's not as if the beast is actually being hurt or whipped or lashed. He may be doing it for show as far as his audience is concerned. But the fact that you cage the animal, the fact that you perform the animal within that enclosure, even without hurting him or it or whatever, it still amounts to cruelty in the larger sense. Yeah, I hope I've made myself clear. So therefore, a whole set of performance animals were taken out from circuses, and we have rules under the Prevention of Cruelty to Animals Act, etc. And performances today, therefore in India, you cannot have these type of performances with lions. Why? With lions and tigers. Why? The reason is that is per se cruel, having regard to the nature of the animal, having regard to its body structure, having regard to its well-being. So you may have a tradition, but this has been found to be something, as science advanced, as we developed our understanding of knowledge and animal behavior, etc., bad. Now let's come to bull. So all of that is now out of the window, it's closed and it is over. Now we come to this nature of this very important question on culture, for example. What the court found, and what I am commending to the court, even without relying upon the judgment, essentially is that converting a bull into a fighting animal. Now you will find that expression also in Nagaraj's case. The whole notion and the focus is fighting animals, making it fight in whatever manner. Its whole reaction of the animal is to flee, actually, if it finds danger. It's fight or flight, and mostly the findings are, in terms of bull ethology, is flight. That's how it has evolved over the years. But if you compel it by having all sorts of noxious things, by prodding it, by physically violating it, etc., it amounts per se to cruel treatment, and the language which is used is very much stronger insofar as the judgment itself is concerned, torturous, etc., etc. So the equation is this: having regard to one, the behavior of the bull, plus two, the anatomy of the bull, compelling the bull to engage in fights, and in this type of what your lordship said, Jallikattu, in the sense the event of Jallikattu, with whatever safeguards, with all the best safeguards, will still amount to cruel treatment which falls foul. So this is the answer.
Why you are saying that they are genetically having the tendency to flee?
They are.
Basis for that. You are saying that genetically.
He'll place the science, but the science.
They are having this tendency.
So just have a look at now. I'll go back to the judgment.
That judgment.
No, the judgment is recording
Based on the report.
on the basis of
The report.
No, not on the report. So let me just tell your lordships now.
Divan.
Now I am answering this question.
Only one thing I wanted to point
Yes,
out.
of course.
My current brother has done his graduation in zoology. Yes.
Okay, Melon, then I am at a disadvantage. But let me.
That is why we want to know. That is why you explain genetically.
No, so let me just answer that, Manoj. It may not be sort of comport with zoology, but I'll just explain the situation as I understand it on the basis of the findings. Yeah, and actually we've got a huge amount of other material which is zoological, but I didn't have the courage to place it before the court, but now I will, because we'll place that also material before the court. So essentially it is this: as far as the behavior is concerned and the zoological elements are the behavior. First, Manoj, I'm on the behavioral aspect. The behavioral aspect, this court, after a study found, on the basis of studies which were placed before it, found that, look, there is a flight or fight response which is programmed into this animal over millennia. That's one. And the second element of the zoological element is that the manner in which this bovine creature is structured is such that compelling it to fight, not fight one, even fight amongst it, would amount or cross the threshold insofar as cruel treatment is concerned. So it's based on science, and it's based on an evaluation of the science. Now it could well be that you have a situation where the science might evolve at some point of time and the science may be different. But today we have the advantage of that. What happens because scientific studies, that's the nature of science. You question a situation and you find data and material in the future. But the overwhelming material and the data is that as far as the science is concerned, as far as bulls are concerned, they are not, in the manner of speaking, for a contest or a fight biologically between humans and the bulls. That's one. And given, I don't want to repeat myself, the element would be. So, let's to answer the question, yes, there may be a tradition, let's call it a tradition, or there may be an age-old custom. However, that in itself, with all the protection, would still amount to cruelty. That's my short answer. With all the protective measures, it would still amount to cruelty, and it would be cruelty on this particular species as a whole generally, and it would be cruelty to the bulls which are in the performance arena. These are not performing animals, and therefore the element of cruelty comes in. And so it can't be trumped according to us.
Okay.
Yes.
Mr.
Sorry.
Divan, perhaps
But I'll revisit these paragraphs.
you have tried to answer this,
Yeah.
but my question still remains.
Yeah.
I'll just put it once again.
Yeah.
You have looked into the element of cruelty so far as the bovine animal is concerned.
That's right. Yeah. I have looked at
But
it primarily.
I am also looking at the cruelty to the young man
Yeah.
who is pining to marry the daughter of the local landlord,
Right.
and that Jallikattu is the only chance for him to woo that girl. I'm not saying it in a lighter vein.
Right.
Suppose that is the only opportunity available for the young man
Yeah.
to marry the daughter of the local landlord,
Right.
who has a bull racing or bull available in a Jallikattu function.
Right.
What about the cruelty to that young man?
I don't think it's cruel at all. I don't think it's cruel at all.
You are taking away the only opportunity. People prepare, people write poems, people do all sorts of things to woo the girl
No.
that they wish to have.
I don't say no. So I would describe this as a deprivation of opportunity for advancement, for sure. But I think a deprivation of opportunity for the young man or the young woman, as the case may be, for advancement is a deprivation of opportunity. It is still not cruelty. The cruelty is being inflicted on an animal which is required on our current understanding of science to do something or perform something which is completely contrary to what the animal in the nature of its design and biological functions, etc., is capable of doing without being cruel.
Anyway,
So this is one element of the answer.
All right.
So I am basically, in one sentence, what I'm answering the question is, in just one sentence, both the sets of questions is, that really the cultural and the tradition argument does not, in my respectful submission, hold water in the sense that if an activity has been found to be cruel even otherwise, independently, on the basis of the science and the material, then I don't believe the fact that there is some cultural advantage to it ought to allow this kind of cruel activity to continue further. That's the basic point. Of course, I have a much more layered argument and a much stronger argument, which is all of this has been gone into by this court. It's all been examined threadbare, and having recorded findings of fact and not been reopened and reviewed. I don't think there is and there's no material on the record which seems to suggest it's not. So now let me just come further, and this is something which is worth noting. It is one thing if the legislature found that the legislature said that on the basis of new scientific material, etc., we have come to the conclusion that the zoological and biological conclusions which were drawn by the court do not appear to be correct. And in fact, this is the material which is on record. And therefore, we cure this or remove the substratum of the judgment. Please note two factors. First factor, the Act comes into force on 21st January 2017. I'm only on Tamil Nadu at the moment. So it is prospective from 21st January 2017. It does not even purport to take away the foundational basis of the judgment insofar as factual determinations on the aspects which I have just mentioned are concerned. Because you can have situations where you have that, we find that the court was misguided, etc., etc., and we said that Jallikattu was never practiced and it was always good for the bull, etc., and the bull enjoyed it or whatever it did. And therefore, we are taking away the bound. So that this is not such an act at all, which is in the nature of correcting or removing the foundational basis of the judgment. by operating from 21st January 2017 into the future, it maintains this judgment. Please note that. It maintains the judgment insofar as the finding, it does not even purport to. The other submissions is whether it could have done it even for the period prospectively are different. But this is not a case where the substratum of the judgment is sought to be removed. It's just an alteration which is being made for the purposes of the way forward. That's a very, at least according to us, that's an important criteria which the court will keep in mind. Now, my lords, would your lordship, your lordships have the paragraphs on your fingertips, but there is a considerable detailed evaluation over here, and the court is quite right in terms of the discussion on performing animals beginning from paragraph 43 onwards of the Nagaraj judgment. And it's a fairly exhaustive discussion. And the finding is bulls, therefore, in our view, cannot be performing animals anatomically, nor designed for that, but are forced to perform inflicting pain and suffering. Paragraph 44. Paragraph 44 of the Nagaraj judgment. After considering the various materials, etc., on the record in the context of performing animals. Now, there's one other point which I just want to mention. Just at this stage.
Yes.
Yes, so I'll just state the point and then I'll come back to it. But since Justice Rastogi mentioned a very pertinent and important point regarding, look, what do we look at? Do we look at the rules or do we not look at the rules? What this court, I'm just answering the question, and I'll cite the decision. What is to be looked at is the effect of the law. And just broadly, what this court has held is that when there are infringements of fundamental rights, etc., there is a cosmetic law, you're right, there is a cosmetic rule, there's a cosmetic provision, etc., which says X should happen and Y should happen. But ultimately, what is the ground effect of the law? That is what is to be tested. Whenever there is a complaint to the court that some constitutional or other provision is being infracted. But effect of the law. Menaka Gandhi. So I will cite that. Should I cite it right away?
Just give the list.
Yeah, I'll give that list and I'll give you the paragraph and I'll read that one passage, for example.
Yeah.
So it's effect of the law. Now, what you will find, just to answer this point, is maybe I'll just deal with it right away. So your lordship may just note, since we are on it, that the citation for Menaka Gandhi, you may just note, is 1978, 1 SCC 248.
Paragraph, you can just give the
Yes, assistance, according to me, will be paragraph 19, last part, and I'll just give you the page 299.
We'll go through it.
Yes, I'll just read the 10 lines, which I'll just read.
The passport, madam.
Sorry? Yes, the passport. Correct. So I'm on the relevant portion that I'm relying on. I'm relying on 2-3 other paras, 16, 19 and 20. But I'm just now I'm reading just now 19, part of 19 on page 299. The majority took the view that it is not the object of the newsprint policy or its subject matter which is determinative, but its direct consequence or effect upon the rights of newspapers. And since the effect and consequence of the impugned policy upon the newspapers was direct control and restriction on the growth of circulation of newspapers, the newsprint policy infringed freedom of speech and expression and was hence violative of Article 19(1)(a). The pith and substance theory was thus negatived in the clearest terms. And the test applied was as to what is the direct and inevitable consequence or effect of the impugned state action on the fundamental right of the petitioner. It is possible that in a given case, the pith and substance of the state action may deal with a particular fundamental right, but its direct and inevitable effect may be on another fundamental right. And in that case, the state action would have to meet the challenge of the latter fundamental right. The pith and substance doctrine looks only at the object and subject matter of the state action. But in testing the validity of state action with reference to fundamental rights, what the court must consider is the direct and inevitable consequence of state action. Otherwise, the protection of fundamental rights would be subtly but surely eroded. So the point being made is, by all means, look at the rules. And I'll have something to say on the rules as well. But ultimately, you had a 2009 Act, and there was a very abysmal state of affairs. You now have a 2017 Act along with the rules. And that state of affairs continues, even though there may be some window dressing in the sense they'll show you some photograph. They didn't contradict any of our specific, I showed you one report But we have reports for each of the years which we placed on affidavits by way of IAs, etc. No one says that this event was never held. No one said that it wasn't held in this, or that these particular those statistics which were startling as to the number of injuries which are considered, the number of deaths, etc. They are all startling, and they remain, at least as far as I can tell, completely uncontradicted. So this is now one thing. Now, Manoj, may I just pick up the thread, and I want to just pick it up with the observation which was made by Justice Bose yesterday. Now, the observation was in the context of Madan Mohan Pathak. So I want to just cite that judgment, give you one paragraph. I'll like as yesterday, I'll summarize the facts and just tell you. So Madan Mohan Pathak is a decision of 7 learned judges. It is reported at 1978 to SEC, page 50. And I'll just indicate what happened over there. The Calcutta High Court had issued a writ of mandamus. And the mandamus was in respect of payments being made, etc., pursuant to a certain settlement, LIC. There was an amendment, there was an act to the, there was an amendment by which the effect of this was taken away. What our court held was, and this has been now, your lordships know, Madan Mohan Pathak has consistently followed, that a mandamus cannot be undone through legislation. That's a very, very important principle. A mandamus cannot be. And the relevant paragraph is paragraph 9 at page 67 of the SEC report. And here again, your lordship, we've given, of course, the citation, but I'll just read those 5 or 7 lines. Here the judgment given, it's on page 67. Here the judgment given by the Calcutta High Court, which is relied upon by the petitioners, is not a mere declaratory judgment, holding an impost or tax to be invalid, so that a validation statute can remove the defect pointed out by the judgment, amending the law with retrospective effect and validate such impost or tax. But it is a judgment giving effect to the right of the petitioners to annual cash bonus under the settlement by issuing a writ of mandamus directing the Life Insurance Corporation to pay an amount of such bonus. If by reason of retrospective alteration of the factual or legal position, the judgment is rendered erroneous, the remedy may be by way of appeal or review. But so long as the judgment stands, it cannot be disregarded or ignored, and it must be obeyed by the Life Insurance Corporation. We are therefore of the view that in any event, irrespective of whether the impugned act is constitutionally valid or not, the Life Insurance Corporation is bound to obey the writ of mandamus issued by the Calcutta High Court and to pay the cash bonus for the years so-and-so 75, 76 to class so-and-so employees, etc. So a mandamus cannot be undone. Now, a mandamus so I'll just build on this, on the point which the question which came a little earlier. Please note, this is not a case of a validation statute which has taken away the basis. This is a case, I would argue, even if we are wrong on everything else, this is a case this is an act operating on and from 21st January 2017 insofar as Tamil Nadu is concerned. So it is not seeking to validate and remove the basis as erroneous of the past at all, the finding standard, and that is correct actually, because the state government ought not to have done anything to undo the judgment. Now, having said this, just now let me just state the point on the mandamus, etc. And then, mandamus, as your lordships are fully aware, is take 2 shapes. First, it is order and direct A, B, C to do this. Second alternative is forthwith forbear from doing A, B, and C. I mean, this is basically positive or negatively styled. Now, please look at our judgment, the Nagaraj case, and just see the mandamus. Please go directly to paragraph 90 first, and you will find paragraph. So let's see the mandamus, and then we will just see how this is to be read. So it's at page 601 of the report.
Just 1 minute.
Yes, certainly. So, of course, there were the general arguments on separation of power, but now this is a very specific argument. If there's a mandamus, it has to be obeyed, it can't be undone.
Possibly the argument of state would be that the foundation on the basis of which Nagaraj found the particular acts to be cruelty to animal, those were being removed.
Yeah, but
through the amendment and the rules.
right.
Possibly that would be the state stand.
I think that's right. Your Lordship is correct. So that kind of cosmetic removal by amending some definition and putting an exception clause here and there is not going to help the state according to us, because what is inherently cruel remains inherently cruel and you can't undo it.
No,
So,
because
sorry.
some forms of cruelty have been retained by this PETA itself, like slaughtering animal for religious purpose.
Correct. I am not by the.
So
Yeah.
here legislature has chosen to decide which part of cruelty should be prescribed
Yeah, you're right.
and which cruelty should be permitted.
Right.
So here, to what extent we interfere with the legislative exercise
Right.
and interfere into their power to categorize which part of cruelty would be permissible, which part of cruelty would not be.
Right. I agree. I will endeavor to answer that. That's important. So now just have a look, if your Lordship would, at page 601. Please go to, page 601 of the report. So just have a look at paragraph 90. We therefore hold that AWBI is right in its stand that Jallikattu, bullock cart races and such events per se violate sections 3, 11(1)(a) and 11(1)(m)(2) of the Prevention of Cruelty Act, and hence we uphold the notification dated 11/7/2011 issued by the central government. Consequently, bulls cannot be used as performing animals either for Jallikattu events or bullock cart races in the state of Tamil Nadu, Maharashtra or elsewhere in the country. So this is a mandamus as we understand it. So apart from all the general arguments we have made, this is specific. You will forbear from allowing bulls to be used for the various reasons which we have given. Then what it does in the operative directions is, so it issues this declaration, it issues this forbearance in 90, and then it expands it, the operative directions in para 91, it goes to a larger scope to the 5 freedoms with regard to animals, and your Lordship will say, therefore, that as far as the directions which are subsequently contained, 91.35, etc., are more generally worded, not just confined to bulls, but for animals more generally. So that is something which your Lordship should do. Now, since we are 91.3 and 91.5 are also very specific on this in terms of the mandamus, governments are directed to take appropriate steps to see that persons in charge or care of animals take reasonable measures to ensure the well-being of animals. And 91.5, so-and-so is directed to ensure that the provisions of section so-and-so are scrupulously followed, meaning thereby that the person in charge or care of animals shall not incite any animal to fight against a human being or another animal. Now, this is a very general direction which is being given. And I don't believe, so this, anyway, I have made the point, which is that this deserves to be followed right through. It can't be undone. And you may just note, since we are on this, in paragraph 24, para 24 of the same judgment, which is at page 578. (23) and 24. Now, this is before the judicial, so I should mention, the judicial consideration comes later on in the judgment. But 23 and 24 at page 578, after seeing all the facts before them, we have also perused the recent affidavit of Srimati Uma Rani, the Secretary AWBI, MOEF Chennai, on 7th of April 2014, giving the details of the manner in which Jallikattu was conducted in various parts of Tamil Nadu, like so-and-so, etc. And the torture and cruelty meted out to the bulls, which is unimaginable. We notice that situations in the same is the same in Maharashtra. The details furnished in the second by the second respondent in IA, along with photographs, depict the state of affairs, which is also cruel, barbaric, inhuman, and savage. The report highlights the manner in which it is being conducted, and then it goes into further details. So this is the factual context in which it was held: barbaric, torture, cruelty, unimaginable savagery, etc. So, beloved, that is something which the court will keep in mind. So, our point, therefore, is that this is a completely colorable legislative exercise. Now, I have left that alone. Now, I come to my second point. Now, I'm done with that. I will, of course, answer your Lordship's question on the larger issue regarding the legislative carve-out. Now, it's possible, and particularly with your lordship's deep understanding of various facets of animal anatomy, etc., when the question arises, would a larger bench, because your lordships are sitting in a larger panel now, and the question arises as to whether it would be at all prudent to overrule. So I'm on two. One is legislature can't do it. Now I'm done with that point. The question now is there an occasion to overrule as far as Nagaraj is concerned, even though it has survived the review scrutiny? My respectful submission, I'll just state the point and then I'll just give you a couple of judgments. My respectful submission is that as far as precedents and as not precedential value, but as far as final determinations by this court are concerned, which have attained finality, they ought not to be overturned except in certain narrow situations. What are those narrow situations? The first, which your lordship has noted, is if it is per incurium. And per incurium, at least on my understanding, would be without knowledge, say, of a certain statutory provision, of a certain binding precedent, and things of that nature. That is not the case here at all. The Nagaraj case is exhaustive, looks at everything in terms of international law, local law, very, very pertinently, constitutional provisions, notifications, statutes, etc. And therefore, it is not passed in ignorance or without notice of any. So that whole per incurium element, according to us, fades into insignificance. And then, of course, there was a review element also, which it survived. The second grounds which your lordships have said is that, look, there may be certain situations where there is manifest injustice. And manifest injustice is caused because, for example, I mean, this is a case which your instance which your lordship, where, for example, natural justice in its most basic element is not followed. Then that becomes the party is not heard, notice is not given, etc., etc. Then the binding, then there may be an occasion for the court to feel that if there is such a patent miscarriage of justice, then we will overrule the decision. A third category is that if there are certain procedural safeguards which are allowed over there under the law, but those procedural and other safeguards which are fundamental in nature were not comported to when the earlier decision was rendered. So these are the type of categories of decisions, very narrow, rare cases where a decision is overruled. So this is, Manoj, essentially my point. There are two decisions that I want to cite in this regard. The first one, my lords, is a judgment of Justice Sawant, and the report is at 1993, Supplement 1, SCC, page 96. And the paragraph that I am relying upon is paragraph 85, which is at page 145 of the report.
The page of this.
Sorry, the page itself of the citation is 96. It's 1993, Supplement 1, SCC, page 96. I think it's 96 and then the SCC report is 96 into brackets 2. The relevant portion is in para 85. Your lordships have this Kaveri water disputes case?
Number 2.
Yes, number 2. Correct?
Number 1 and 2.
1 and
2 is a reference.
Reference. That's part of it. That's absolutely correct. Now just see the concise manner in which our court, sitting again in a constitutional bench.
This was that interim order controversy.
This was on.
Whether it had power to issue the interim order.
This was on the reference.
All of this has been considered in the natural resource reference also.
Yes, you're right. You're correct. Correct. So the portion I am relying upon in para 85 is about a few lines down. The decision of this court on a question of law. Your lordship has it. The decision of this court on a question of law is binding on all courts and authorities. Hence, the said clause. Hence, under the said clause, the president can refer a question of law only when the court has not decided it. Secondly, a decision given by this court can be viewed only under Article 1, reviewed only under Article 137, read with Rule 1 of Order 40 of the Supreme Court Rules 1966, and on the conditions mentioned therein. When further this court overrules the view of law expressed by it, in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decision. It does so in exercise of its inherent power and only in exceptional circumstances, such as where the earlier decision is per incurium or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. See Bengal immunity. Under the Constitution, such appellate jurisdiction does not vest in this court, nor can it be vested in it by the President under Article 143. To accept Sri Nariman's contention would mean that the advisory jurisdiction under Article 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive has a power to act, a power to ask the court to revise its decision. If such power is read under Article 1, is read in Article 143, it would be a serious inroad into the independence of the judiciary. So the point which we try to encapsulate here is it per incurium, Nagraj? The answer according to us is no. Is there the absence of material facts? The answer is no. All the facts were considered correctly. And is it in any manner manifestly wrong? We believe not. And finally, is it productive of public mischief? The answer is also absolutely no. So therefore, there is no occasion, we would respectfully submit, for Nagraj to be overturned. I have to still answer your Lordship's question with regard to the subsequent statute. No, I accept that.
I have another question apropos your submission.
Yes, of course.
Because there are many cases where the fundamental basis of an earlier decision
Yes.
is later on overruled by a bench of higher strength.
Yes.
Say the tribunal Sampath Kumar case.
Yes. You're right.
Chandra Kumar
Yeah.
overruled the fundamental basis. It was not a par incurium, it was not a public mischief.
Yes.
But
It had to do with the design of the constitution. And
Yes.
what remedies are available under what's the constitutional architecture for redress?
or for that matter, Golaknath and Keshavananda
Yes.
and Shankari Prasad earlier.
I agree. But
These are all fundamental basis of the judgment
I agree with you.
has been altered
Correct.
by later on by a bench of larger strength.
Yes.
So it's not that these procedural aspects solely form the basis for alteration of the earlier view of the case, but substantive provision or other substantive reasoning
Right.
also can be altered by a larger bench for whatever reason.
So there, I would suggest to the court that I would suggest on the formulation which comes from the court. I would suggest there are two responses that I have. The first response that I have is that since certainty, predictability, insofar as a decision of a final court is concerned, are elements of rule of law, there is a restraint on a larger panel and a larger judge. I'm not saying you can't do it. Of course you can do it. You're sitting in a larger panel, and therefore this is a self-corrective machinery, as the court is correctly observing. But even that self-correction, in our respectful submission, is not attracted in the facts of this case.
Retrogressive.
Yes.
It would be retrogressive.
Yes, it would be definitely extremely retrogressive. It would be retrogressive for sure. That is certainly, your Lordship is correct to that is our submission. But in any case, I would submit, and I would like your Lordships to also. I'll just hand over not hand over. I'll just give your Lordships the Antule case citation also. 88-2 SCC page 602. So now that was a case which had come up inter partes, because this is also in a manner of speaking inter partes. So Antule is 88-2 SCC 602.
Shyam Divan says,
Yes.
See, the bulls have been domesticated.
Yes.
So they are not actually performing, they're not adapted to fighting. They have cousins living in the jungles. You have got some material. It seems as they particularly fight over the cows.
Yeah, that's true.
Now,
We have a judgment of our court on the wild buffalo.
that's right.
In
While
Chhattisgarh.
you have seen it in the documentary,
Right,
you
yeah.
see that how vicious they can get,
Correct,
before
correct.
the fight.
Oh, I think that's quite right.
So when you say domesticated, there is
Yeah.
one significant feature here,
Yeah,
taking on what my learned brother Roy said,
yeah,
part of tradition, culture, and they have a case that these bulls are specially reared in such a manner
Yeah.
that food, the difference between the bull and the cow,
yeah,
apart from being male, female,
Yeah.
as is common to all species,
Yeah.
It's much more muscular, little taller,
Right.
and the content of the body, I mean, it's such that it can withstand fight. Like all males in respect to female, normally.
Yeah.
Normally.
This is not a bullfight between two
No, no,
bulls
no, no.
over a mating preference.
It's not. What you're saying is something different. What
Right.
you're saying is, if for thousands of years they have this custom, tradition,
Yeah.
but not about custom. I don't be thinking I'm
Tradition. Yeah.
that they have been preparing that it's not as if domesticated, being a domesticated animal, they are not fit for performing. They are in fact trained for performing. Centuries, they have trained, this is a tradition which has been handed down to them. So they are actually, they are honed, they're especially sort of adapted. Not the, ordinary domesticated bull everywhere. Like you have, material which show.
I don't think that's the case, but I'll just check up.
They have that key.
No,
They are being rare, they treat them with the greatest affection otherwise. That's their cases. It is not as if they are antagonistic to the bull. They rear them, they treat them like a member of the family. And finally, when this just part, you see, for example, there are two ways of looking at it. Man always has an interaction with animals.
Yeah, it does.
Man has an
Correct.
interaction. It is at various levels.
Correct.
You can be playful with your animal. The animal may even be hurt in the course of that playful encounter. Nobody will say it's cruelty. I don't think you will say it's cruelty. You have a dog, you play with it, you make it run, you do like all kinds of things. Nobody calls it cruelty. Only when it touches a particular level, like you put artificial things, chili into the eye, things like that. There obviously nobody will permit that to happen.
No,
That is what
obviously,
was happening earlier.
obviously, where does your lordship arrive at that? Obviously, it is being happening and it continues to happen.
Obviously, we are saying it is happening and it is wrong. We are not for a moment saying that the court, that is where the courts came in, stepped in and said that is wrong.
Right.
That is
Correct,
not
correct.
going to happen at all in the future.
But it's
Unless we
happening.
say-
I've given you all those reports which are not
What
contradictory.
my London brother here said, we have to look at what the rule provides for. We'll have to see that it is ensured, that it is guaranteed, that the rules are complied with. We can't be proceeding on the basis that the rules will be violated and therefore the rule is bad.
No, okay, so let me respond to that. So first of all, the rule is being violated and it's being violated wholesale because I've given you uncontradicted material, which is, I've read it only from 1 year, but that 1 year report of 2022 also summarized what was found in the previous years in the text portion of it. So it's an extraordinarily cruelty. So now that's just, I'm going to respond to this point itself.
First point that they are specially trained. This species are, in Tamil Nadu, they have this tradition and the bulls are being trained.
That is what they have said, that there is a certain type of bull, if your lordship just sees the act. If your lordship will just see the statute itself. Just see the amending statute
That's right.
and the SOR. Well,
One more thing.
Oh, volume. Yes, yes.
Besides Peruncurium, is it any case of a subsilentium? That is also one of the grounds, which can be gone into taken into account by the higher court.
Sub-silent. Sorry, but I didn't follow the question.
You said that normally when a decision is there,
Yeah,
the bench of course, the more strength.
right.
Of course, whether they can look into that question.
Yes,
You said that, of course, Peruncurium, that can be gone into.
yes.
But at the same time, a case of a subsilentium can also be.
So let me answer this issue on sub-silent. I'll just formulate my answer.
There is also instances where these can. On that possibility. Besides Peruncurium, subsilentium.
Yes. So now I'm just endeavoring to answer the question which was put. Let me at least supply my understanding of the law as far as revisiting a decision of this court is concerned. I believe it's absolutely clear on the strength of the decisions I said that there is no intra-court appeal insofar as this. I think that's absolutely clear because that's the Justice Sawant judgment. Please don't just make us an intra-court appeal because you're sitting in a larger combination, etc. So that's out. That's one. The second pillar is that, look, there is a recourse under the Constitution, which is Article 137. And of course, your lordships have created under the Rupa Hura case one more curative scheme if there's some great miscarriage of justice. But even that is a much narrower area than even available insofar as review jurisdiction is concerned. The third element which I want to flag is that because rule of law is so important and the credibility of this court as an institution is also dependent on finality of judgments, there are restricted categories. I'm not saying, I don't think there's any wisdom in defining all the categories available to the court. I think that will have to be kept open-ended. But illustrative of the sort of cases where a larger panel may revisit is a situation, and one is per incurium, which I have made my submission may not apply over here because the facts and the law have been looked at exhaustively. That's one element. The second question is, and which we pointed out, if there is some completely fundamental error. Now, one of the fundamental errors could have been that, look, where are animal rights? You have mentioned animal rights in your final operative direction is that please give a constitutional rights. What is this notion of animal rights, etc.? It's a fundamental error. The answer is no, that's not a fundamental error because the court has very carefully used the expression animal rights in two contexts. One, not because we are saying X or Y or Z or that we are overturning Salmon on jurisprudence. No. There is an express duty which is cast as far as human beings is concerned. And the corresponding element the court has described as a right. That's about it. Not as if there is some right by which an animal can go to court tomorrow and say that please enforce this right. And there are 5 universal freedoms which I have taken your lordships through. So that's the context in which animal rights as a compendious expression has been used to capture these broadly. So there's no fundamental flaw on that as well. Now, if that is not the case, the question I ask myself is, what is the great error in terms of some public cause? Because that may be also, there may be some, I think those L. Chandra Kumar, etc. cases which were given to me, which were cited and rightly so, were in case of the entire constitutional machinery in terms of redress. So that is one. Then you have a large number of cases, your lordship recalls, even in the arbitration field as far as section 11 is concerned. 2 judges, 3, 5, 7. It kept going up and there were alternate and then there was a legislative intervention. So that also had to do with some fundamental issue insofar as commercial law is concerned, and the court found that it had to correct or fine-tune, etc. But there was something fundamental with having huge and enormous public impact. I don't believe those criteria are met over here at all. As far as sub silentio is concerned, my understanding of that doctrine is that you could have certain situations where there is an undercurrent which is running through a judgment which is not completely and fully articulated. Now, I don't believe there is some such articulation over here in Nagaraj which makes it vulnerable. That's my submission. The articulation insofar as Nagaraj is concerned is express. It is right there in the face for each one of us to read. It is very well reasoned and well considered. That's my point of view. And ultimately, whether right or wrong, it doesn't fulfill the criteria in our respectful submission, which would invite an overturning.
Sub silentio operates in the field of precedent.
But precedent
It may not have any application here.
It may not, because yes, as a larger panel your lordships have held, you may be able to rob a smaller combination's judgment of its precedential value.
Then, so it's
Yes.
for the purpose of here,
Yes.
here we are
May not quite arise.
we are not dealing with precedent.
Yes.
Here we are dealing with the question whether the legislature can take away the right.
Yes.
That
That of course on the larger point.
That is it.
Now just have a look at the act since your lordship put this to me. The act itself is at page 137 of volume 1.
Yes.
I'm not taking you through the analysis because Mr. Luthra has already done so, but I thought I'll just point out page 137 of volume 1 of the convenience compilation. An act to amend the Prevention of Cruelty to Animals Act 1960 so as to preserve.
1 second.
Sorry. Yes, I'm so sorry. Okay.
Lighter note, Shyam is telling, we are actually never asked the bulls whether they would like to have a run with the human beings. Give it back to them for what they have been doing it to.
There was
an opportunity for them.
There's a famous article, which was a scholarly piece written by an American scholar in, I think, the Yale Law Journal in the 1970s on should trees have standing? Should trees have standing? And so then he explained it in as to why trees should be given standing, which was a question which your lordships also had come up. Let's give them standing so that they can, whatever, forest rights, etc. Then there was I can only describe it as rather cheeky and cute response which came in some Harvard Law Journal or something, where he says exactly what your lordship said. That look, I have a river which has been flowing for millions of years, but I want to be dammed. And then it talks about another mountain slope, I remember, which says, look, I want a ski lift for tens of thousands, millions of years I have had no ski lift, so please put a ski lift, please damn me, etc. But it was meant as a cheeky response. But your lordship is quite right. We cannot. Now, in this regard, there's a whole developing science now on sentient creatures, and I'll cite just one article on that. When you have creatures themselves, now the science is indicating that they are capable of feeling pain. They're feeling, they're not emotions, complex emotions as you and I would understand that expression. But then what is to be done? So I'll come to that separately. But now I'm answering the question put to me with regard to these traditional, the species of bull. Now just see what their act says, the amending act. An act to amend the Prevention of Cruelty to Animals Act so as to preserve the cultural heritage of the state of Tamil Nadu and to ensure the survival and well-being of native breeds of bulls. Now, I strongly commend to the state of Tamil Nadu, and we support anything and action being done for the well-being of the native breeds of bulls. By all means, as your lordship correctly said, they are worshipped. Of course, they should be worshipped. They are looked after and with the greatest love and care. Yes, please do that. But can you subject them to cruel treatment? As a justification, the answer is no. But now let's see what they have said first. So see the definition of Jallikattu in double D. Jallikattu means an event involving bulls conducted with a view to follow tradition and culture on such days for the months of January to May of a calendar year in such place and may be notified by the state government and include so-and-so, so-and-so, so-and-so. And then your lordships will see the carve-outs which are conducted in the conduct of, please see in 11.3e, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the preservation of native breeds of bulls and also their safety, security and well-being. There is not a jot, there's not one line which says that because of that, unless we hold Jallikattu and subject it to all sorts of inhuman and cruel treatment, that this particular native species of breeds is going to be unwell or it is not going to be secure. So what our respectful submission is, there are a huge line of traditional bulls in India, except and obviously cattle, bovine creatures. Those lines, some of them are outstanding. I mean, in terms of, I'm talking bovine, male as well as female, for the purpose, say, as far as milk production is concerned. Others may be very strong animals for the purposes of pulling, etc., and draft animals. Yet others may be have utilities which are otherwise. And you may have utilities and you may want to preserve bulls, etc., and traditional bulls because of their size, because of their beauty, because of their horns and all sorts of things. So we are not against that at all. please do so. Please set aside funds. Please create goshalas or whatever you want and preserve these bulls. But that doesn't mean you subject them through a carve out over here to cruel treatment. That object itself, this is the point. That object itself, after a determination of this court, is per se illegal according to me. Is preserving your tradition and culture illegal? No. Emphatically no. You may do so. Is preserving a breed of bulls bad or illegal? Answer is no. It is, of course, it is good, and in the interest of the bulls and the species, we must encourage it. But is continuing a event which is defined over here as Jallikattu, which has been found by this court and which has been found by these reports as inflicting untold misery on the animals, those specific animals which are worshipped at other times of the years, that is clearly not permissible. It's an illegal object. So anyway, there is nothing here which your lordship will find in the statute itself, apart from these particular, and also in 27, the amendment, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the survival and continuance of native breeds. This event is not dependent, the survival of native breeds is not dependent on Jallikattu at all, is my respectful submission. It's absolutely irrational, according to me, and it is manifestly arbitrary. Now, there is also a statement of objects and reasons to the Act, which I just placed before you, because there's one line in that as well. And I just indicate, it refers to the Supreme Court judgment in Animal Welfare Board, has found that the conduct of Jallikattu is violative of the provisions of the Central Act, particularly 3, 11 and 22. Considering the vital role played by the event of Jallikattu in preserving and promoting tradition and culture among the people in large parts of the state of Tamil Nadu, and also considering the vital role of Jallikattu in ensuring survival and continuance of native breeds of bull, the government of Tamil Nadu has decided to exempt the conduct of Jallikattu from the provisions of the Central Act 59 of 60. Therefore, the government has decided to amend, etc., etc. So I would respectfully submit that when you apply the traditional test under Article 14 of having some sort of a reasonable classification, for example, that is not met, because here, frankly speaking, while the state might have an objective with regard to a particular type of bull, there's nothing on the ground to show that there is X or Y or Z. But those bulls must be preserved. I'm not saying that line must be preserved. But this is not a condition, precedent, or even a requirement for preserving that line of native breeds at all. There's no rational nexus at all, and certainly not if it is subjected to this kind of inhuman and cruel treatment. That's my respectful submission.
While you're on Article 14,
Yes.
you also raised the argument based on Article 14.
Yes.
Because 21, almost you have given up. Actually, you are not pressing that line of argument. 19 is obviously not available because the bull is not a citizen.
21, I told your lordships,
We have already said that. I mean, we have taken note.
and you recall, I read that report about people dying.
People dying. That argument is there. Actually,
Yeah, so-
not the animal as such being a.
No, and then I gave that penumbra argument, but I did, but your lordship is saying is absolutely right. I am not saying the bull has an Article 21 right, if that's the question being put to me.
No, we are putting something in.
Yeah, but there's an element of dignity.
You brought in manifest arbitrariness.
Yes, that's 14. And dignity,
that is
because
very-
dignity is an important asset, other council will develop it.
That's-
Dignity under 21 is an important facet of 21.
That's right.
And maintain, once we have a judgment of this court, apart from the non-retrogression argument, allowing something which is so cruel and torturous to a bull and compelling it to fight and contest lowers the dignity of each one of us. That's the submission, but that's someone else will develop. So I'm not putting sort of 21 into a waste paper basket for the purpose of my case, but it's not something which I'm going to elaborate on because others will do it.
I think please read Article 14.
Yes, of course.
Just read Article 14.
Yes. Yes. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Correct.
The question we are putting to you.
Yeah.
For the purpose of Article 14,
Yeah.
it doesn't matter whether you are a citizen or you are not a citizen,
Yeah.
but you have to be a human being. The word person. We're just putting it to you so that you can just clear because the same argument which you very rightfully,
Right.
in a manner of speaking, give up the context of Article 21, personhood.
Right.
Whether the same problem will arise
Right.
in the context of Article 14 using the word person.
Right.
Can you say that?
No, so
animal is
it
a
doesn't
person?
arise. It doesn't arise. So let me answer that. We are on the text. Let's answer that straight away. The protection under 14, couched as it has, prevents or proscribes the state from violating equality in whatever manner. Obviously, the impact eventually will be on a person. But now let me answer respond. Supposing you have an arbitrary classification which doesn't deal with persons at all, but it says there's an arbitrary classification in a schedule to a taxing statute. There's an arbitrary classification with regard. So it has nothing to do with a person as such. You may only have companies, etc., which are impacted by that taxing statute.
It will always relate to a person.
Yes.
Yes.
It will not see that.
So everything will come back to a person.
Classification relating to inanimate things,
Yeah.
but it relates to the right of a natural or a legal person.
That's good.
We are just trying to put you that I don't use
Right.
Otherwise, you can't be having something in the abstract. It will always, rights are always related. They are
Yes.
always relative. There is no absolute right in the first place to begin with.
Right.
If
They
you
are
will lose your
qualified.
life,
You are the subject
when
to.
your
Correct.
life is not absolute.
Correct.
So when you are talking about right in the Article 14,
It must come back to a person, Manoj. I'm not saying for a moment that it doesn't come back to a person. So, sorry.
so there, how will you actually deal with it?
No, so I will deal with it in this manner. I will deal with it in the manner that as far as 14 is concerned, I'll just explain, at least as I understand it, the evolution of the law. Initially, your lordships interpreted 14
Classification.
as a basis of falling foul of a classification test. And this was a manner. Of course, fundamental rights are in a sense linked to individuals. They may be citizens, they may not be individual citizens, and as your lordship says, it may be a corporate person as well. No problem, difficulty with that. So, in the first realm, the construction and the manner in which this court interpreted it was on the basis of the classification test. Then your lordship supplied a further dimension to the issue, which was with regards to arbitrariness. So, arbitrariness also became a factor and even dehorsed the classification test if some action was found to be arbitrary. Then again, it was liable to be or potentially liable to be struck down. Now that doctrine has further evolved and has further dimensions. Manifest arbitrariness is yet another factor or an aspect of it. And 14 has now been read with along with 21, 19, etc. and draws sustenance from all of them. So my respectful submission is the manner in which 14 appear. Yes.
There is one more issue there
Yes.
when we flag it.
Yes.
You see, how the law is developed from a mere classification. Of course, we had Anwar Ali,
Yes.
right from Justice Vivian Bose, made.
Yes.
But apart from that, the milestone is, of course, manifest, where you
Yes.
have a different approach to Article 14.
Yes.
So all of this is founded on a triangle approach. The
Yeah, I agree.
triangle is
Yes.
14, 19, and 21.
I believe that's correct.
Correct. Now, because the unenumerated rights in Article 21,
Yeah.
rights which are proclaimed specifically in 19, you can find them, discover them, which has been done very effectively by this court in 21.
Right.
For all of that, you need the indispensable, the sheet anchor is, you need to have the premise 19 as well. Now, 19 obviously will not be available to an animal because he's not a natural person under the Citizenship Act. Only a natural person, as you know, the line of decision which says that a corporate body cannot, for example, maintain a 32 by itself. It should have natural shareholders. So, unless and until you have 19 also being available, which is impossible in the case of animals because they can never be citizens of India. How do you bring in the theory of arbitrariness for animals? They're just dumb.
Yeah, so I'll just explain that to you.
You want this?
No, so let me just explain that to the court. Okay. So there has been, your lordships are correct in, identifying various markers in the development of our constitutional law. Now there are two elements over here to it, which have worked simultaneously, particularly since the mid-80s.
Yeah.
One element has been the lowering of standing. And along with the lowering of standing or the lowering of the threshold for standing, locus standi, you had equally an expansion of rights under our Part 3 to extend and to cover rights which were, in a manner of speaking, not articulated expressly in the Constitution, but were found embedded because the value was there, and therefore, as the Constitution has been interpreted as an organic document, etc., moving forward, those have been ready. So now take the example I gave yesterday was the simple example of the right to a healthful environment or a wholesome environment. So that's not mentioned anywhere in our Constitution, but it was derived right from the 1980s when you had, for example, the Dehradun quarrying case, and a 32 petition was entertained, even though it was only in the early 1990s that for the first time it was said that the right to a healthful environment is actually embedded in the Constitution and in Article 21, and therefore we will engage 32. Now, what is the consequence of these two? What you have is situations. Now, for example, I'll just indicate, take something like the Wildlife Protection Act. That was also mentioned by Mr. Luthra. Now, in the Wildlife Protection Act, broadly, you have protected areas in its latest iteration. So you have, broadly, national parks and you have sanctuaries. And then you have other protected areas as well. Now, when you have a national park and a sanctuary, one way of looking at it is that, look, if there's a national park and supposing the boundary of a national park is arbitrarily altered, I'm giving you an example. Who are you as a human being to challenge it, etc., under 14, 19 as being arbitrary? Because ultimately it's a question of the animals, etc., and they are not coming forward and they have no rights under 14, etc. But because we have lowered standing, because we have expanded the right under Article 21 and Article 14, it is available to a citizen to come forward and challenge an aspect, say, of the Wildlife Protection Act with regard to the alteration of a state boundary or of a national park boundary. Equally, now I'm coming to another example. You have schedules to the Wildlife Act. So certain schedules, that was also referred to by Mr. Luthra. So certain animals which are in a schedule enjoy the highest degree of protection no matter where the animal is. So even if whether the animal is in a sanctuary or outside the sanctuary, take a tiger for example, you can't kill a tiger except in terms of, so it could be well outside a protected area. Then there are species, all species are protected within a protected area. Certain species are protected whether within or outside the protected area. That's the broad scheme of the act. Then you have protections for plants, etc. also under that particular act. Now, if there is a violation or a movement, say, of a species which has enjoyed a higher degree of protection to a lower degree of protection, then the question is, what is to be done? So, is there any violation which has taken place? The answer is that through the human agency, this court has allowed. Now, for example, at 3 p.m. today, there's a special bench which is being constituted in Court 1. What is the thrust of that case? There is a bird called the Great Indian Bustard. It is on the brink of extinction. Now, the challenge in that particular petition under 21 is it's not that the bustard has come to the court over there and said that, look, my fundamental rights under 14 and 21. But there is a violation of rights because the state action has been found, or there's already an order of April 2021 of this court, finding that certain directions and rights have been infringed. The directions, certain action, I shouldn't say certain action has been found to fail the rationality and reasonable test qua a particular species. So the answer is not that that species fundamental right under 14 is violated. The answer is, in the context of that species, action which is being taken is arbitrary. And that allows an individual under the lower threshold under Article 14 to approach the court. Of course, a person may be right, a person may be wrong. But the threshold point which your Lordship is correctly putting to me, that look, if 14 is meant only for a person and 21 is only meant for a individual human being, then what happens insofar as bulls are concerned? So through a human agency, whether it is an animal protection agency or whether it's a statutory board like an animal welfare board or whatever, so what's our case? Just go back to the Nagaraj case. That's key before we had this act. What were the broad thrust of the case at that time, the earlier round? The broad thrust of the case was that, look, you have, apart from, I'm keeping aside this business about legislative competence, keep that aside for a moment. The point was that, look, you have a statutory board called the Animal Welfare Board, etc. This and the state, which is under a constitutional duty to protect bulls, is failing to do so. And the court, alive to this consideration and constitutional duty and responsibility, enforced it through its judgment. Now the judgment is available to us. So this is broadly how I would respond to 14. And I would respectfully submit that I don't think, I mean, of course, there's no second guessing what the state of Tamil Nadu will argue or any of the other states. But my sense is that the law has developed now by which an individual or a group or a registered society acting bona fide can approach this court and point to certain actions which are arbitrary, etc. So arbitrariness comes in another manner as well. It is a facet. It's a when you have, if we are right, or even if if we may not eventually be right, but if there is some case for consideration, let me put it no higher than that, where a state seeks to overrule a Supreme Court judgment and breach the doctrine of separation of powers, which is fundamental to our constitutional scheme, I believe a group can bona fide come before the court. Your Lordship will put each group to the test and say that, look, are you really bona fide or not? That's a separate answer and a threshold.
Yes.
I understand, I didn't know this, but I understand that Mr. Nagaraj had lost his son in that earlier round. He had lost his son in Jallikattu and therefore was seeking relief, etc. And including direction. That's the genesis of that earlier matter.
Awesome.
So there are dimensions of that. That is, of course, a direct impact situation for the foundation of the case. But this is broadly where we stand on our understanding. Now, since we are on 14, let me just tie up this submission by referring to one 7-judge bench judgment. I'll just give you the citation and I'll give you the paragraph. It is Nagpur Improvement Trust versus Vittal Rao, 73-1 SEC, page 500, and the relevant paragraph is para 26 at page 506. Now, let me just, while the book is being located, there's just one paragraph I want to read. While the book is being...
Most quoted judgment, actually.
I see, 73-1.
Number.
Your Lordship will recall the facts. The facts were there were two methods of acquisition of land. One under the Improvement Trust Act, one under some general acquisition law, etc. But it was resulting in different sets of and different amounts being available to the party. In that context, 14 was examined and looked at very carefully. Is the book there?
Prior to this, Manil Gandhi.
Yes, 73. Yes, it is prior. It is prior. So, beloveds, I'll just indicate what the paragraph said, and
Basically, it's a part of the classification test.
Yes. So, but it's got one dimension. First of all, Your Lordship is absolutely right, correct in your recollection. It's pat on. It articulates the test. Now, the element which I am relying upon is not just that the classification should be clear and precise. That's one element. Second element is that it must have a rational nexus to the object being received, to be received. But there is one threshold requirement even prior to this. Even if your classification is clear, even if it has a rational nexus to the object sought to be achieved, there's one element which is at times forgotten, which this 7-judge bench articulates and is followed in a subsequent Supreme Court judgment, several, as Your Lordship said, but a constitution bench in Subramaniam Swamy as well. And that is that the object itself must be lawful and this is very, very important for my purposes. So the question being put to me is, or was put to me a little while earlier was, that look, you want to protect species of local bulls, etc. Is that an unlawful object? Certainly not. It's the most lawful object. But the issue is the means and the ends. You want to protect your a certain indigenous species, etc. By all means, do so. But the manner of doing so, the object in that sense may be good. But to allow Jallikattu to do so is impermissible in law. That's an impermissible object. It's not a lawful object according to us. Yes, I'm sorry.
See, that observation was made in the context of the twin test.
Yeah.
In the context of the classification theory.
Absolutely right. It is purely that.
That object should be lawful thing.
Yes.
Itself
is
a part of the classification theory.
Well, first of all, I agree with that. Absolutely. So the argument therefore is...
So here there is no problem about classification. We are not on classification at all.
No, we are on classification.
No. Here nobody has raised the argument of classification.
Of course there is. It's a square on.
Please tell us.
Yes, the classification. Yeah, all right. So I just articulated in the most basic sense.
Yeah.
Bulls form a single homogeneous class. As far as bulls are concerned, as a classification. Now, if you are creating a certain subclass to subject certain types of bulls alone
Okay.
to cruel, unusual, torturous treatment, that is impermissible in law. So that's the traditional classification test, one element of it.
We'll never argue, that's why we're telling.
Oh, I see. I thought I heard Mr. Luthra say it. He said it. But anyway, now it's just a one single sentence point. So that's the point. So that's the first traditional point. Now I come to the second element. So I am trying to argue this on on the traditional test under 14 and on the more expanded test. So now I'm completing the second sentence is also on the traditional test. So therefore, my point is that you ought to, I can't say must, but the legislature ought to be alive to the interests of all the bulls of that species. You cannot create an artificial distinction over here and certain bulls who are subject to torture, etc. If your object is to allow the entire species, etc., to flourish, by all means do so. So this is an impermissible classification of bulls which are put in the ring and which are subjected to unusual treatment. So this is one part. Second,
where is your pleading in this regard? Have you
the
made
14 ground.
No, have you raised a pleading?
I hope it's there.
Yes, we also hope it is there.
14 point, Malod, it's a
No. This point is interesting. So that we'd like whether you're serious about it.
I have certainly, I must confess I've not seen it in my pleading, but I've not seen my pleadings at all. I've seen the reference questions which your lordship put to the court.
Right.
And that articulates 14 as one of the questions which has come up before this larger panel.
14 in the context of manifest arbitrariness is different from classification. So there we are asking you whether there is any pleading which you are now seeking to sort of argue.
I think if there is at best, it will be some general pleading, but I'll try and locate it. Now, in any case, so the point here is 14 is very much there. 14 has various dimensions. Once the other side is on notice that there is a 14 issue, it has to be prepared and ready to answer all dimensions of 14. 14 is an evolving issue and 14 is in the reference order. So anyway, I will try and locate it from the pleadings, but I'll just tell your lordships. So this is one element. Now there's a second element to 14 in terms of the classic. So one is, so all bulls form a single, I mentioned that element. Now we come to the second. The object itself must be something, in the context of classification, Lord, in the object, what paragraph 26 says is that in this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be discriminatory. For otherwise, for instance, if the object is to discriminate against one section of the minority, discrimination cannot be justified on the ground that there is a reasonable classification. It's the same thing. So that I have made that point. The object is bad. Why? Because you cannot subject certain animals to cruelty. I mean, because we have a judgment in our favor on that, and I don't believe that can be really overturned. So that's the second element of it. The third element, why the object is bad, again, traditional classification test, is because it is completely in breach of the doctrine of separation of powers. So yes, you may strike it down as colorable under separation of powers, but dimensions of 14 also kick in over here. Why? Because your whole purpose, your statement of objects and reasons mentions a judgment of the Supreme Court, and thereafter you say that I want to decide on the facts in the case. I want to decide on culture, etc., which is already decided by the Supreme Court. How is that permissible is the question I ask myself. So anyway, that is in itself, in our respectful submission, in the most traditional form of violation of 14. So now, Manoj, I'm done with 14.
The legislature not say that this is culture.
Yes, so now let me answer that. Let me answer that straight away. And I am in this regard fortified by the judgment of the Constitution Bench judgment of this court. So just allow me to go back to one paragraph in the judgment of Kerala versus Tamil Nadu, which I had cited yesterday. But let me answer the question. The answer to the question as we understand it is...
No, we remember that paragraph.
Yes.
Where you said that the purpose of a legislation cannot be to take away a vested...
No, not that. So first of all, let me try and furnish an explanation if we are right. I'm only answering the question. The legislature, which is plenary, may in many, many situations, virtually all situations or almost all situations, have, say, a deeming fiction. All right. So let's start with that. So can make a man, a woman. I don't know whether gender analogy is really very relevant at this time, but
tomorrow says morning is to be called.
yes. So you can have a legislature which says morning is evening, sun rises on this side, etc. No problem with that. You can have a deeming fiction. That's the general traditional notion of the plenary power of a legislature, so long as it has subject matter competence. But then, with the progression, we have situations where the court decides. This is the most crucial factor. Once the court decides, this court or any other court, but certainly as far as this court is concerned, and it decides on an element of fact, not just based on fact, but it decides something on facts, and it decides an aspect of the law, namely, in this case, to answer the question as to whether there was a cultural root to a particular, and rejects it, then the legislature cannot overturn the judgment of this court through a legislative process, because that violates separation of powers. So to answer the question, could they have done this before? Could they have done it? They did it through the 2009 Act, and I concede that instead of doing it through the 2009 Act, they could have amended the prevention of. For my purposes, I've conceded that because I've said it falls under 17 of the concurrent list. For my arguments, someone else may have another submission. So I'm conceding that position that they could have done this in the first instance. The point I'm making is they cannot do it after the Supreme Court judgment, because that's what violates separation of powers, and that is why this court held that after this court in Kerala versus Tamil Nadu has said that, look, 142 feet is the dam is safe up to 142 feet. The Kerala legislature cannot, on an appraisal of facts, come and say that, look, I am deeming it that it is safe only up to 132 feet. And after that, the board is to decide. You can't undo a judgment of the court. That's the point. Once there's a factual determination, the whole arena shifts and moves into another space. And the matrix for evaluating the correctness of a judgment would be different before or after, even though you may have had a deeming power before that. So, my lords, now I'm done with this particular thing. Your lordship has already read that portion which says, cruel, barbaric, and inhuman and savage. Now, once a judgment of this court holds that certain conduct of Jallikattu is cruel, barbaric, inhuman, and savage, I would respectfully submit that any object to advance that kind of a practice is per se illegal once this court has so held. So, anyway, I'm done with that submission. Now, my lords, there's one article on the sentience, and then I'm just going to go to those other 2-3 points which remain. So, on the element as far as sentient creatures is concerned, there's just one article that I want to read, and that is just to explain, because this is a recent article in 2018 or 19. Have it given it? So, I should just mention, there are 3 pieces, 3 scholarly works which are already there in the convenience compilation. I am referring to the most recent one, which is in this new volume which I am handing over, and I am going to read only 2 or 3 paragraphs of this. So just so that you have an, just very quickly, just 2 paragraphs from this. So please go to page 8.
Yeah.
Now this is a piece by Suresh Kumar, Sanjay Chaudhary et al. And it has been published, your lordships may just note, in the Animal Sentience, the title your lordship knows, it's in the International Journal of Current Microbiology and Applied Sciences, published in August 2019. You'll find that number and the reference right at the very top. Now, what is this new understanding? Let me just see. See the first paragraph. Sentience is the ability to perceive and feel things. An animal is sentient if it is capable of being aware of its surroundings, its relationship with other animals and humans, and of sensations in its own body, including pain, hunger, heat, or cold. In 2012, an international group of eminent neuroscientists signed the Cambridge Declaration on Consciousness, which confirmed that many animals, including all mammals, and birds possess the neurological substrates that generate consciousness, it is logical to suppose that sentient animals also enjoy feelings of comfort, enjoyment, contentment, and perhaps even great delight and joy. A sentient animal is a being who has interests, that is, a being who prefers desires or wants. These animals naturally try to avoid suffering and seek positive experiences. Just like humans, animals have evolved to cope as successfully as possible with life in the wild, thousands of years of domestication of farm animals, etc. So this is just to give you an introduction as to what is sentient and what is the direction in which the science is moving. And then your lordships may look at it in your, if your lordship, should your lordship consider it appropriate. I think it's a very nice article, brings us up to date. Please go directly to page 16, just in the conclusion. You will find in the right-hand column, sentience and cognition. The attribution of sentience to animals can also be hindered by the common misconception that capacity for sentience is linked in some way to the species' cognitive ability. Cognition refers to the mental action or process by which animals perceive processes and store information. Sentience, on the other hand, refers to the capacity of an animal to have feelings and to be aware of a variety of states and sensations, such as pleasure and suffering. It is often assumed that cognition and sentience are inextricably linked, in that cognition automatically implies sentience. Indeed, evidence of higher cognitive abilities, such as theory of mind and language, has previously been used as a basis for advocating for the rights of certain species, such as the great apes. Cognition is not actually a prerequisite for sentience, and it can be demonstrated independently. Developing our understanding of animal sentience is imperative for improving animal welfare and attitudes towards animals. Concentrating on filling the gaps in our knowledge humanely and reliably is essential given the extent of human impact on animals. With increasing attention on animal sentience, science and the further development of human approaches, the future of the science of animal sentience is looking even more promising, and as a result, so does the treatment of animals. So I am trying to only urge to the court that on part of that non-retrogression argument, that the science is actually moving in the direction and pointing in the direction which our court pointed us to in 2014. So this is the short point that I wanted to make with regard to sentience. Now 2 or 3 points remain. One is in answer to your lordship's question yesterday with regard to those rules, and Justice Rastogi raised it this morning. So let me just hand over what has happened as we see protective measures and guidelines, and then come on here, take it. Give it to the other side. Now, very briefly, those reports which we gave, as I mentioned, and which we placed year upon year, have not been meaningfully contradicted.
Yeah.
Now, just let us see how this works. This table, your lordship has the tabulated statement.
This is the most important part, actually.
Very well. So, all right. So,
No, because this is what.
no, this is weighed with the court. So we put in, I mean, some effort. Let us hope it is adequate. Now, let me just summarize what broadly where we come out from. In one line, it's all old wine in a new bottle. That's one general comment which I want to make.
Yes.
The second comment I want to make is that, look, while there may be a particularization under the 2017 Act rules, because the 2017 Act I placed in the morning, there's nothing really in that, it just carves out an exception. While there may be a further particularization, broadly what you will find is that the particularization, according to us, was already captured by some general catch-all phrase or responsibility or duty earlier. So please keep that in mind. That's number 2. And the third thing is that certain features which were present in 2009 are in fact diluted insofar as 2017. The other 3 broad points. So let's just see how this works. So now see the Tamil Nadu regulations, regulation of Jallikattu Act 2009. I'm on the first page. So regulation of Jallikattu. So the first is, no permission under subsection 1 shall be granted to any person to conduct the event unless the collector satisfies himself that the event is conducted in January to May, the place selected is suitable for orderly conduct, The event should have been conducted during the past 5 years continuously. The event shall be held in a place notified by the collector in the district. Then we have set out, my lord, section 3.2 for your reference. Now look at the responsibility which was imposed on the organizer. Every person who organizes the event shall take all precautionary steps for the orderly conduct. Inform in writing if the collector, to the collector 30 days prior to the date of the event and obtain his permission. Double barricade the arena way through which the bulls pass, though in order to avoid injuries to spectators. Fix up the gallery for the spectators to sit and watch the event. 5. Arrange to obtain prior permission of the collector to persons who wish to bring their bulls to participate in the event. 6. Ensure that the bulls are put through proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to that effect. 7. To arrange and enroll the names and other particulars of the bull tamers in the event, with the collector at least 15 days prior to the holding of the event, and the bull tamers shall also be put to a thorough checkup by a medical team. Ensure that every bull tamer wears an exclusive dress for the sake of identification. Deposit with the collector a sum to be determined by the collector, which shall not be less than rupees 2 lakhs, etc. And then we have mentioned over here, overleaf on page 4, this has been omitted under the asterisk portion. Those responsibilities, we have said, have been omitted in so far as 2017 is concerned. Now, just moving on, carry out the responsibilities that may be prescribed. Then the arrangements made to be made by the collector, a very important section 5 of the 2009 Act. Collector shall ensure, so organizers' responsibility, now collector responsibility, ensure double barricading, ensure that the number of spectators does not exceed the limit under the prescribed by the PWD, ensure safety certificate by PWD, ensure that the bulls are free of any diseases and not intoxicated or administered with any substance like nicotine, cocaine, etc. Arrange and provide adequate police protection at places where the event is held. Arrange to provide adequate medical facilities, including the ambulance at the places where the event is held. 7. Arrange the necessary drinking water supply as well as sanitation facilities in place where the event is to be held. 8. Authorize the officer not below a rank of deputy collector to look after each item of the event arrangement, like checking up of the bulls, checking up of the bull tamers, checking up of barricading, gallery arrangements, medical facilities, water supply, sanitary arrangement, and safety of the spectators. Arrange to give wide publicity to the provisions of the Prevention of Cruelty to Animals Act 1960 and the rules framed thereunder, and the risk involved in participating. Ensure the presence of animal welfare activists representing the Animal Welfare Board. This has been completely removed in 2017. Videograph the entire event and provide the same to the government or any other authority as required, and make such arrangements as may be prescribed. Now I'm pausing here for a moment. This is a reading of Section 3, Section 4 of the 2009 Act and Section 5. Now, I first make my comment and then I go on to the right-hand side. After this, had the court's approach been, which I don't believe may have been a correct approach, subject to, of course, what your lordship said. If the court had said, Nagaraj, that look, these are rules, these are sections, these are statutory provisions, everything is fine, everything is perfectly conceived, etc. There is really no occasion. If there is someone remiss, if there is some deviation, then the recourse is for the party to be prosecuted or penalized or take action, etc. Answer is no, that may not be the correct approach. The correct approach for the court was what it did. It examined reports and affidavits, detailed reports and affidavits, where each of these obligations, your lordships have seen it, I don't want to take you, as far as the safety and sanitary conditions are concerned, as far as the violence and the pain is concerned, as far as the alcohol and other elements are concerned. I'm talking about Nagaraj. I'm not talking about my report. I'm talking about the reports and the affidavits which came before this court, which are extracted in extenso. And the court found that despite these so-called safeguards, the whole thing is illusory. And therefore, given the cruelty being heaped on the animals and the injuries, etc., which are being suffered, and the cruel and inhuman treatment, it doesn't comport with our sense of dignity. It doesn't comport with the requirements of the Act, the Prevention of Cruelty to the Act, and the purpose of the Act. Now see what they have done in 2017. I'm going to read this all on the right-hand column, again serial number 1. I'll read them in full. The act itself is just the carve-out. So now they have the rules. Set out the procedure for conduct of Jallikattu. Rule 3.1. Any individual or organization intending to conduct Jallikattu in a place so-and-so under section 2DD shall inform the collector of the district. Same thing is there. Organizers shall also obtain prior permission from the collector. Same thing is there. The collector shall grant permission for any Jallikattu, cause an inspection of the venue. Exactly the same as was there earlier. 3.4. Provide for formation of a committee of Jallikattu, which includes revenue, animal husbandry, police, health department. Your Lordship recalls the earlier provision was to the same effect. Namely, these people had to be involved. Rule 3.5 specifies that the organizers have to ensure that the bulls are tested properly by the animal husbandry department. There was a mirror provision earlier. Provides for the collector shall ensure that help of animal husbandry department.
Don't rush there.
Sorry?
3.5 is important because
Yeah.
it says, and no performance enhancing drugs,
Yes.
irritants,
Yes.
etc. are administered to the
Yes.
correct.
Yes.
Now this word irritants, etc.
Yes.
Because when you're challenging a law,
Yeah.
it's always open to the court to actually read it down, to make it constitutional, as you are aware.
No, so see the earlier provision.
Because earlier provision did not provide for etc. irritants, etc. So
But I just read the earlier provision. The collector had to ensure that the bulls are free of any diseases, not intoxicated or administered with any substance like nicotine, cocaine, with the object of making them more aggressive or ferocious.
there were performance enhancing narcotic substance.
Yes.
I mean, that apart, what we were really concerned, and we're going to put it to Tamil Nadu also,
Yeah.
whether they have, prevented, like spiking, like poking it with.
Of course, that's prevented, Manoj.
That is whether that is there or not in the rules.
But they're definitely there. The Tamil Nadu government is not allowing any such treatment. That can't be done. But it is being done. The problem, just imagine, as your Lordship sees, if in your time your Lordship goes through the photographs, you will see it. That those prods and those things are being used, and the whips and the lacerations, etc. are there, and those are documented in the text.
Were CCTV cameras, was it there under the old?
Yes, it was. Videography was there. So, brothers, as technology evolves now, you will have a live streaming also. We are not on that. But earlier, videography was there. I read it. Please just see the earlier rule. Where, sorry, page?
Videography may not be the same.
Page 5.
Videography
No,
may
page
not be
6.
the same.
Page 6, 9.
Page 6.
Right.
CCTV camera
Prominent
monitor
model.
all activities.
Videograph the entire event.
Yeah, videograph. You're absolutely right. It's 11. I think it's 11.
CCTV
Aye.
camera, Shyam,
Yeah.
CCTV camera to be fixed to record and monitor all activities is different from videography. Because videography, if you are going to capture only the parts, which are really palatable to their side, you may not get the whole picture.
Well, I
I think
think
CCTV camera, as long as it is working, if you're not allow it to work, is a different matter.
your Lordships have experience of CCTV camera. Can I share something?
Yeah.
Yeah. The CCTV camera is, apart from being an obnoxious invasion of privacy, because you see it all over the city just now. Not just public streets. We now have a mandate in this city that you have CCTV cameras in schools. One thing which I thought we were left with was at least childhood, where you can, we now have CCTV cameras in classrooms, etc. But anyway, that's for another day. Now, the point I'm making is that the CCTV camera enables you to reconstruct in certain situations. The granular condition of the feed which you get may or may not, because a lot of it depends on the angle from which the CCTV camera and the event which takes place. So, since your Lordships have allowed me to share a personal experience, I can tell your Lordship that I know of a particular person, a close relation, who had CCTV cameras which were installed for security purposes. The persons who engaged in mischief just shifted the CCTV camera in another direction, etc., and did exactly what they pleased, and thereafter refitted the CCTV camera or whatever in the manner. So CCTV camera, while it may serve a certain purpose. I'm not saying it doesn't serve a purpose, but essentially the benefit is not going to be with respect to those particular bulls for whom we have come over here and to prevent cruelty. It may, in some instances, prevent some reconstruction of events and to say that, oh, I said this and you said that. But you are not going to be able to really, in my experience, enhance your law enforcement. So the purpose of this, now I'm coming to this. the purpose of the CCTV camera across the world, by and large, is, and your lordship actually said it, that the CCTV camera should work. CCTV cameras are stationed in many parts of the world only to ensure that the action which a person takes is somehow, is to prevent improper action. Actually, those cameras are there. There may not even be a camera inside. There may be no feed. But the idea is it's a tool of deterrence. Because there's a CCTV camera, and X or Y or Z may feel that, oh, I shouldn't do X or Y or Z. But in reconstruction of crimes, etc., it may be possible. It's of course at a cost. But what I am trying to suggest to the court is that by having some, some small little improvement here and some, embroidery over there,
The basic rule.
the basic rules were there in 2009. Despite the basic rules in 2009, you had widespread violations which have been now found to be established. And therefore, my urging is twofold. The first urging is that perhaps, possibly, a wiser way, or maybe I'll withdraw that expression wiser, but a better way of examining this law, the present impugned law, is the effect of the law and not based on the theory. Why? Because we had a submission, we had elaborate rules earlier, statutory provisions in a section earlier, but those failed to pass muster. They did not result in any meaningful alteration in conduct of the event which would be beneficial. Am I suggesting that every Jallikattu event? No, I am going by the basis of the record. The Supreme Court will the 2014 Nagraj judgment. I just gave you from one or two of those particular districts. It would be wrong to take up your lordship's time and read each one of them. At so many of the districts, the court found brazen violation year after year. Now, if you have this kind of treatment with statutory provision, this was, don't forget, this was sections in the Act. This was not even subordinate legislation at that time. Today, it is subordinate legislation. Not that its subordinate legislation should be flouted. I'm not suggesting that. But it was a higher order, the 2009 State Act, which was completely breached wholesale. So, to complete, at least for this first set of obligations on the collector and on the owner, pari material, you may not find it court by court, but essentially the person has dressed it up and put it in the form of rules where all those say, because I'll tell you why. The reason I'm making is, I don't think the intention of the state as such, it was obviously the 2009 Act, the idea of the state was, it was hopeful of having some regulatory exercise. I'm not suggesting that they were some, the state government, they were not acting, they were acting bona fide, but even when they were acting bona fide in 2009, the legislature, on the ground, it didn't yield anything at all, as this court has found. And putting this old wine in a new bottle and trying to market it ought not to pass muster. So this is the first point. Now let's go to the second set of, please go to page 6. Now look at section 4 earlier. Ensure that the bulls are put to proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to the effect in such form as may be prescribed. Ensure that the bulls are free of any disease, not intoxicated, etc. So this was 4, 6 and 5, 6 of the section. Your lordship has page 6, serial number 2. Now the your lordships have page 6. So the left-hand side, left-hand column is 2009, correct? Now look at the rule 4 at page 6. Now look at rule 4 on page 6. Examination of bulls. The bulls shall be compulsorily subject to veterinary examination by qualified veterinarians of the Animal Husbandry Department. Now, obviously, when the earlier Act also envisaged, the word veterinarian may not be used, but obviously the Animal Husbandry Department personnel would be all vets. Otherwise, where's the question? Who? A general lay person in the secretarial staff has no competence to say whether there is nicotine, cocaine.
Quantitative difference from the earlier section 4 with what you have put on the right-hand side.
Right.
The earlier thing was see that are not administered any performance enhancement drugs not administered, number 1.
Yeah.
to ensure free from any disease and
Yeah.
not.
These are not a quotation. You should just know. I've asked them to paraphrase it.
That's-
Just telling you, it's not a quotation.
That's right. That's
Yeah,
right.
it's a paraphrase.
But if you contrast it with
Yeah.
what you find on the right-hand side,
Yes.
they include both
Yeah.
showing symptoms of fatigue, dehydration,
Correct.
restlessness
Correct.
shall be identified and not permitted.
Yes.
These bulls shall be examined specifically for possible alcohol and any for subject to any such abuse shall not be allowed to participate.
Right.
So it is more elaborate.
I agree with you. I am for a
More
moment.
elaborate and goes to detail.
So may I just answer that? May I just respond to that? First and foremost, it is not necessarily more elaborate in the sense that it was not covered earlier. So I'll just explain that. You might have had a particularization in the 2017 rules,
Correct.
which was not particularized in the 2009 Act, but it was covered by the 2009. Well, let's
The
be.
matter goes to substance.
No, I'll just explain.
Particularization itself is such that it knocks out the basis of the cruelty according to it. That, for example, if you see
No,
a particular bull,
Yeah.
see, there are bulls and bulls.
Ah,
They
yes,
may be
yes.
trained, they may be fed.
Right.
Correct. But at the time when the actual fight takes place or the Jallikattu takes place,
Yeah.
then the officer whom we have to pursue by statute ordains that he should perform a particular act.
Yeah.
So he performs his act. Let us assume that the act actually goes on well. That's one way of testing the constitutional
But
law.
I agree, but that is, if I were
That
arguing in
is so.
2013,
The bull showing dehydration, restlessness, identified, not
Right.
permitted to participate.
right.
So this was not there earlier. They were not
No, it was very much there earlier.
No.
And I'll show you the corresponding provision.
not there.
No, I'll just show you that. Just give you the equivalent to that. We'll give you the equivalent provision as well. So, Manoj, I want to just respond to that situation. You had rules in the form, rules in the sense, I'm using the expression in the form of detailed statutory provisions in the section under the 2009 Act, which corresponded to this. You're quite right. The word vet may not be used, the word animal husbandry department may be used. But specifying a vet doesn't mean who else in the animal husbandry department would know X or Y or Z. There may be some further, with the advance of science, for example, you may have a substitute of videography with a CCTV camera because CCTV cameras may be cheaper, etc. But that in itself is not a qualitative difference from the perspective of the bull.
Rule 5 you come to. That is very important. Rule 5 over the page, yeah.
Just give me a moment, please. Sorry.
Rule 5, if you in the meantime, if you may read.
Yeah, Millers of the new rules.
Yes.
Yes.
Over the page, next page, page 7.
Yes, so may I just read that?
There is no equivalent in the earlier.
Yeah, that is so. Arenas shall be at least 50 square meters area. The bulls have to be embraced by the participants within 50 square meter area. The participants shall not be permitted to stand in front of the bulls as they enter. They shall also not be permitted to block the exit way for the bulls. The participants shall be permitted, etc., some 15 meters or up to 30 seconds or sustain 3 jumps of the bull. The participants shall not hold on to the tail horns using their hands or restrict the movement of the bulls by holding on to the bull's legs. The participants violating these guidelines shall be liable to be debarred.
Just pause there for a moment.
Right.
It's a matter of some moment because
Right.
you're talking about the flight response, the fear.
Right.
A large part of this fear can be attributed to the acts of the human being, holding on to the tail. Now, this is that part. We thought that there might be of some importance.
So I'll just tell you, let me just tell
Knocking
you.
out the basis of
So let me just, the foundation of the previous judgment, let me just explain that to you without reading any paragraphs. The idea, I'll just explain it to you in very general sense. So you have a bull, the bull is a domesticated animal. It is being, revered for the rest of the year, etc. And it does what a bull does. Now at this stage, now it's a calm animal. We don't know what's passing through its mind, but it's sentient. That's what the science seems to suggest. It has a certain abilities over there in terms of pain, etc. Now, when it is put in an artificial setting, this is now the performance ring, correct? You remember that the performance was banned for all the circuses. That's why today our circuses don't have it, including insofar as bulls are concerned. Now we are coming to that, whether it's a bullock cart race or this. I am concerned, of course, with Tamil Nadu. Now, what's happening in this context is that suddenly the bull, from doing what it generally does, which is whatever, munching, eating, browsing, etc., it is put into an arena. Now, putting it in an arena itself may cause or trigger a certain panic by which it wants to leave the arena, but it is not able to do so. It wants to flee. The flight or fight response is that generally the bull will fly, it will try and leave, but it is completely barricaded and prevented. That itself is cruel. That itself is cruel insofar as an arena with spectators shouting, hooting, whatever, etc. So there's a panic response. Now I'll just complete, sorry.
Just when you say that.
Yes.
The second sentence of Rule 5.2.
Yeah.
They shall also not be permitted to block the exit way of the bull.
Yes, yes.
Earlier what would happen perhaps is
Yeah.
they would surround it.
Yes, there is.
Create that flight response. So the human beings derive, joy out of it. That is an animal right in front of us.
Of course.
That was the whole idea.
No, but
Now,
you,
they have now made a change. The radical aspect appears to be that they shall not stand in the way. They shall not stand in the beginning, that is in the entry point. They shall not block the exit. So they have made it a little bit, at least.
no, it's like participants, my lords.
I'm talking about the participants.
But who is to tell the bull? The bull, I'm just asking your lordships. The cruelty is because you have a large arena. I'm assuming there's a large arena. You saw some of the reports said there was no arena and it was being conducted in the village center, etc. Keep that aside. Assuming you have a large arena, it's not as if the bull can read an exit sign or something like that and say that this is the way out and I will follow that and someone is blocked. There is a huge, my lord, spectacle going on over there. We have shown you. Now you may have to go to the photographs and see how it's actually conducted. This is not a parade or something which you see while beating the retreat with the horses in a leisurely manner coming. This is a spectacle. This is an event. And it's an event intrinsically. Maybe you may want to condone it. That's another matter. But intrinsically cruel as far as it has been played out in the recent past. Because I don't know. We don't know what the tradition. But at least from 2014, 2009 to 2014, we have a final judgment of this court. 2017 onwards, we have a whole bunch of reports of this court. It is still played out in a cruel and what we term as an inhuman manner. Because of, as your lordship said, there's some sort of a contest. There is some, people are trying to show their whatever notion of strength, etc. Because the bull itself is a notion of strength. But we believe that this is really, from any reasonable perspective, having a gate, which, I mean, I don't think anyone is suggesting that the bull knows exactly where the exit is, etc. It's not really, it's cosmetic. Let me put it this way. These changes are, in my respectful submission, cosmetic, given the overall and given our experience. Why am I going into that? My submission is anchored on facts and on the basis of PETA reports. Anchored on the basis of those PETA reports, this is something which does not happen and the cruelty subsists. Now look at the next thing, point 4, the bull run area. Look at that. So earlier it was double barricade the arena or the way through which the bulls pass through in order to avoid injuries to the spectators. Sorry.
So they'll have to do the explaining. You can perhaps reserve your, if you wish to file a reply. I mean,
Yeah, correct. So your lordships have gone through the rest.
Yes, we have seen.
All right, I'm very grateful. Thank you. So now, my lords, and we have mentioned some parts which are not there. Rest of the table. Fair enough? Okay. So essentially, I mean, in a line, this is a cosmetic change. Right? That's my idea. So
we
just give me a moment.
We have given you sufficient time.
Yes, absolutely.
More than.
Reported judgment.
In this case,
Yes,
as we will
So
demonstrate.
I'll just mention.
so Can we move on?
Yes, yes. Well, I'm done. There's just, sorry.
Cannot hold on.
First, I am done now. I'll just take 2 minutes. I want to answer those questions which were also put to me. And see, just let's look. I'm just stepping back from what has happened. The broad submission that I want to make in terms of the legislature's ability, and I'm going back to the point regarding colorable. Once this court has found that this is inherently cruel, can the state legislature, through an amendment to the Central Act, modify the mandate under the Central Act?
These are suspended submission.
In my respectful submission, I'm just looking at it differently. If the state legislature could do that, what's the effect is the question I ask you. What's the effect? The effect is that a final judgment of this court, which can be only overturned by this court, without removing the substratum in terms of the factual determinations, etc., gets ultimately overturned. And that I don't believe is a permissible exercise, and therefore it is deeply colorable. Now, finally, the answer, can they not make a fresh legislation with safeguards? I have two answers. The safeguards were already there and they were breached earlier. The safeguards introduced since 2017 continue to be breached, and therefore, in our respectful submission, there is absolutely no justification for sustaining this legislation. I'm very grateful. Thank you.
Thank you. Thank you. Who is going to argue?
Yeah.
Tell us one thing. You argued from 2 o'clock to evening. 4 o'clock yesterday.
Yes, I'm sorry. I thought I'll take half an hour.
Without taking a drop of water even. Not water at all, and you're going on continuously. Without even.
This species is not a sentient creature.
With no cognitive ability. I'm very grateful.
After such a long time, and you just either have some sip of water.
I think I should have been briefer. But thank you very much. It was a very nice thing.
So, at least you enlighten us on a different subject. Totally in a different way.
Very grateful. Thank you.
Youth power.
Yes, Giri.
Wait, please, Your Lordship.
Yes, you are appearing for?
It will be big